I have been sitting in my car for 10 minutes trying to figure out how to start this vlog. I'm just gonna go with, I just read Judge Sullivan's response in the Michael Flynn case. Viva Frei, Montreal litigator turned YouTuber, and there have been updates in the Michael Flynn judicial saga, most notably Judge Sullivan's response to the Court of Appeal's order that he respond for his conduct in this file. I think that I am probably rightly assuming that if you are watching this vlog, you are sufficiently familiar with what is going on in the Michael Flynn judicial saga, but in the event that you are not, I have created a playlist of all of my vlogs, including live streams I've done with Robert Barnes on the subject. I'm going to link them right here. Give them a watch to get totally familiarized with what's going on. In the unlikely event that you are totally unfamiliar with what is going on with Michael Flynn, just a 30,000-foot overview. Michael Flynn is a retired United States Army Lieutenant General and was the National Security Advisor to President Donald Trump. Flynn got indirectly caught up with the whole Russia collusion investigation, and despite the fact that the FBI, after months of investigation, found no derogatory information on Michael Flynn, because of their incompetence, according to one of the FBI members, they had failed to close the investigation into Michael Flynn. As the general public learned in April 2020 as a result of recently disclosed FBI notes, which oddly enough Judge Sullivan failed to mention anywhere in his 40-plus page brief, we learned that the FBI sat Michael Flynn down for yet another interview, bypassing the standard protocol of coordinating with the White House, ostensibly for the purposes of getting Michael Flynn to lie so they could either prosecute him or get him fired. And the FBI apparently got Michael Flynn to provide a false or misleading statement on a transcript of a phone conversation that the FBI had in their possession and Michael Flynn knew they had in their possession. On the basis of that allegedly false statement and other threats potentially to investigate Michael Flynn's son, Michael Flynn ultimately pleaded guilty to making one false statement to the FBI. In 2020, Flynn changed attorneys. His new attorneys requested communication of a bunch of documents which included disclosure of these FBI notes, potentially showing that the purpose of that meeting was not to obtain the truth, but rather only to entrap Michael Flynn. On the basis of that newly disclosed information and evidence, Michael Flynn sought to withdraw his guilty plea. The Department of Justice made a motion, effectively a motion to drop the charges against Michael Flynn. Subsequent to the Department of Justice's motion to dismiss, Judge Sullivan, who was the presiding judge, instead of granting the Department of Justice motion to dismiss the charges against Michael Flynn, seemingly in defiance of Supreme Court precedent, instead unilaterally appointed an amicus curiae, a friend of the court, to present arguments in opposition to the Department of Justice's motion to dismiss charges. He also ordered that amicus curiae to determine whether or not Michael Flynn should be held in contempt of court. Subsequent to those orders from Judge Sullivan, Flynn's attorneys presented a mandamus to the Court of Appeal, the mandamus being ordering an official to do something that they are legally required to do. The object of that mandamus being that the Court of Appeal should order Judge Sullivan to grant the Department of Justice's motion to dismiss. Faced with Michael Flynn's petition for a mandamus, the Court of Appeal then turned to Judge Sullivan and gave him 10 days to respond to why he was not granting the Department of Justice's motion. And now we are going to go through Judge Sullivan's brief explaining why he is not granting the Department of Justice's motion to dismiss the charges against Michael Flynn. That is the 30,000-foot overview. Let's begin reading the brief. It is unusual for a criminal defendant to claim innocence and move to withdraw his guilty plea after repeatedly swearing under oath that he committed the crime. Well, the brief is starting off well with a statement that is virtually impossible to confirm or deny. What does unusual even mean in that sentence? People withdraw guilty pleas all the time. That's why there's a procedure provided in law as to dealing with it. A defendant can withdraw their guilty plea for a number of reasons. They can withdraw their guilty plea before or after sentencing. In Michael Flynn's case, he is attempting to withdraw his guilty plea before sentencing. And this qualification to color the file that Michael Flynn repeatedly swore under oath that he had committed the crime, well, we're going to understand what Judge Sullivan is getting at later on in his brief. All right, and I've got to take my jacket off because it's actually getting hot in this car, but let's get back to the brief. It is unprecedented for an acting U.S. attorney to contradict the solemn representations that career prosecutors made time and again, and undermine the district court's legal and factual findings in moving on his own to dismiss the charge years after two different federal judges accepted defendant's plea. And Judge Sullivan might ordinarily have a good point here, save and except for the new evidence that was disclosed in April 2020. You know, minor details that might account exactly for what Judge Sullivan just described. Sullivan then goes on to frame the legal questions at issue. These reversals presented Judge Sullivan with several substantial questions. Was he required to grant the government's post-plea motion to dismiss and reverse his findings that Mr. Flynn's false statements to the FBI about his contact with Russia were material without any inquiry into the facts set forth in and surrounding the government's filing? What implications would dismissal have on Mr. Flynn's separate false statements to the Department of Justice about his work for Turkey, which were part of his plea agreement but not addressed in the government's motion? Do the facts here provide reason to question the, quote, presumption of regularity that ordinarily attaches to prosecutorial decisions? And what, if anything, should Judge Sullivan do about Mr. Flynn's sworn statement to the court where he repeatedly admitted to the crime and to the voluntariness of his guilty plea, only to now claim that he never lied to the government government and was pressured and misled into pleading guilty. Because the parties before him now support the same relief, Judge Sullivan turned to an approach used by federal courts across the country, as well as district courts in this circuit. He appointed an amicus to present counter-arguments and set a briefing schedule, giving the government and Mr. Flynn the last word. I just want to open a parenthesis here. When Sullivan says that because the parties before him now support the same relief, the parties he is talking about are the defendant Micheal Flynn and the prosecutor, the Department of Justice itself. We are not in the context of parties with a common interest. On the contrary, we are in the context of parties with diametrically opposing interests, that being the defendant and the prosecutor. The question before this court is whether it should short-circuit this process, forbid even a limited inquiry into the government's motion, and order that motion granted. The answer is no. Mandamus is an extraordinary remedy that should be denied where the district court has not actually decided anything. The government's motion is pending before Judge Sullivan and could well be granted, so Mr. Flynn can obtain the exact relief he seeks through ordinary judicial process. Reading this paragraph, a few flags are going off, namely as relates to mischaracterizing the question at issue. The question is not one of short-circuiting the process and forbidding even a limited inquiry into the government's motion. Judge Sullivan could have conducted a limited inquiry on the presentation of the government's motion to dismiss the charges. But there is a vast difference between a judge conducting a limited inquiry on the presentation of the motion and a judge unilaterally appointing an amicus curiae to basically act as an independent prosecutor to that case. Furthermore, I tend to disagree with the affirmation that the district court, i.e. Judge Sullivan, hasn't actually decided anything. Sullivan did in fact decide two very important things, one being appointing an amicus curiae to present counter-arguments to the Department of Justice's motion to dismiss, and the second to add entirely new charges to contemplate whether or not Micheal Flynn should be held in contempt. Unilaterally appointing an amicus curiae to present counter-arguments, setting a schedule for those counter-arguments, above and beyond basically appointing a prosecutor, that also adds months and months of delay to the process. Justice delayed is justice denied. And above and beyond the injustice of adding further delays, there's the injustice of adding new charges that were not contemplated between the parties. I may be wrong, and if you think I'm wrong, let me know why, but I don't think Judge Sullivan hasn't decided anything. On the contrary, I think he's decided a lot. The statements of offense recounted 3 sets of materially false statements. 2 involved lies Mr. Flynn told to the FBI in a January 24, 2017 interview regarding his contacts with Russia and other countries regarding U.S. foreign policy. The remaining statements involved lies to the DOJ in documents Mr. Flynn filed on March 7, 2017 about work that he and his consulting firm did for Turkey. Mr. Flynn's plea agreement incorporated the statement of offense, and in consideration for his guilty plea, the prosecutors agreed not to charge him further for that conduct. In a section of the agreement binding only on the parties, Mr. Flynn agreed to, quote, forego the right to any further discovery or disclosures of information not already provided at the time of his plea. That strikes me as a very interesting renunciation to compel someone to agree to in the context of a guilty plea. And being a Quebec attorney who is not fully familiar with American law, I do question whether or not the voluntary or deliberate withholding of certain material information would not be cause to undo that guilty plea. District Judge Rudolph Contreras took his initial plea. Judge Contreras placed Mr. Flynn under oath, confirming his understanding that, quote, if you do not answer my questions truthfully, you could be prosecuted for perjury or making a false statement. Mr. Flynn then confirmed that he had, quote, sufficient time to consult with his attorneys and was, quote, satisfied with the services that they have provided. I've got to tell you, I find this to be absolutely mind-blowing. The judge is putting Flynn in a situation where they tell him that if you plead guilty and you are lying to pleading guilty, meaning you are in fact innocent but wrongly pleading guilty, that you could in fact be prosecuted for perjury for doing so. Not just that, but compelling Micheal Flynn to confirm under oath, under penalty of being prosecuted for perjury, that he is satisfied with the legal services provided to him by his attorneys? Who is that intended to protect, Micheal Flynn or his attorneys? Would Flynn maintain that he was satisfied with the services provided to him by his attorneys if he subsequently found out that his attorneys either failed to or withheld material information that would have proven his innocence? I don't know if this is standard protocol under American law, but these were my reflections reading through the brief. Shortly after the entry of Mr. Flynn's guilty plea, the case was randomly reassigned to Judge Sullivan. Thereafter, Judge Sullivan entered a standing order advising the government of its continuing obligation to provide exculpatory evidence to Mr. Flynn pursuant to Brady v. Maryland. We will all later on learn that the government either failed to comply with this ongoing obligation or Micheal Flynn's attorneys at the time failed to communicate this information to him. A full year after Mr. Flynn originally pleaded guilty, the parties filed sentencing memoranda. The government's memorandum reiterated that Mr. Flynn's false statements in both the January 2017 FBI interview and the March 2017 DOJ filings were, quote, material under Section 1001. Mr. Flynn, quote, did not take issue with the government's description of his offense, but his memorandum contained, quote, additional facts regarding the circumstances of the FBI interview alleged to be, quote, relevant to the court's consideration of a just punishment. As a result, the December 18, 2018 sentencing turned into a second plea colloquy. As Judge Sullivan explained, the court takes its responsibility here today, as always, very seriously. Mr. Flynn's briefing concerned the court as he raised issues that may affect or call into question his guilty plea, and at the very least, maybe his acceptance of responsibility. As such, the court concludes that it must now first ask Mr. Flynn certain questions to ensure that he entered his guilty plea knowingly, voluntarily, intelligently, and with fulsome and satisfactory advice of counsel. I cannot recall any incident in which the court has ever accepted a plea of guilty from someone who maintained that he was not guilty, and I don't intend to start today. After being placed under oath again, Mr. Flynn confirmed that 1. He did not wish to, quote, challenge the circumstances surrounding his FBI interview. 2. By pleading guilty, he would be giving up, quote, forever his right to challenge that interview. 3. He knew at the time of his interview that lying to the FBI was a crime. And 4. He was, quote, satisfied with the services provided by his attorneys. Mr. Flynn also disclaimed any reliance on revelations that certain FBI officials involved in the interview were being investigated for misconduct. I suspect that opinion might change with the disclosure of the FBI notes in April 2020, but nonetheless, all of this smells extremely fishy. The court: Mr. Flynn, anything else you want to discuss with me about your plea of guilty? This is not a trick. I'm not trying to trick you. If you want some time to withdraw your plea or try to withdraw your plea, I'll give you that time. If you want to proceed because you are guilty of this offense, I will finally accept your plea. First things first, and call me a cynic if you want, when someone says they are not trying to trick you, this is not a trick.
I immediately think they're trying to trick me, and this is a trick.
The defendant: I would like to proceed, Your Honor. The court: all right, because you are guilty of this offense? The defendant: yes, Your Honor. Only after these repeated offers and colloquies did Judge Sullivan accept Mr. Flynn's guilty plea to making materially false statements to the government. Consistent with his usual practice, Judge Sullivan offered to further delay sentencing to give Mr. Flynn the full benefit of his ongoing effort to provide substantial assistance to the government. Judge Sullivan cautioned Mr. Flynn that, quote, the sentence the court imposes today, if sentencing proceeds, may not be the sentence that you would receive after your cooperation ends. As Judge Sullivan explained, quote, it could be that any sentence of incarceration imposed after your furthered cooperation is completed would be for less time than a sentence may be today. I can't make you any guarantees, but I'm not hiding my disgust, my disdain for this criminal offense. This is not a trick. I'm not trying to trick you. Do you want to proceed with your guilty plea? Yes, I do, Your Honor. Okay, I will accept your guilty plea. And now that I've accepted your guilty plea, shall we delay sentencing? Because if you continue to cooperate with the government, I might sentence you to less time than if I sentence you today. Oh, and by the way,
You disgust me.
I may be a cynic, I may be ignorant, but that seems to me to have played out exactly like a trick. To get a full understanding of the plea agreement struck by the parties, Judge Sullivan also asked the government whether it had declined to prosecute Mr. Flynn for other chargeable conduct, including whether Mr. Flynn's conduct, quote, rises to the level of treasonous activity on his part. The government responded that it was a, quote, serious question that it could not answer on the spot. Judge Sullivan gets Michael Flynn to confirm under oath that he is ready to proceed with his guilty plea. He gets Michael Flynn to confirm under oath that Michael Flynn is satisfied with the legal services provided to him by his attorneys under penalty of prosecution for perjury. After all of that, he then recommends delaying the sentencing pending Michael Flynn's cooperation with the government in another court file. Sullivan then, by his own admission, goes on to say that he can't hide his disgust, his disdain for Michael Flynn, and goes on to contemplate whether or not Michael Flynn committed treason. After a recess, however, Judge Sullivan walks back that statement a little bit. After a recess to allow Mr. Flynn to confer with his counsel about the timing of sentencing, Judge Sullivan explained the reason for his earlier inquiry, clarifying that he had asked about, quote, other potential offenses for the purpose of understanding the benefit, if any, that Mr. Flynn has received in the plea deal, but, quote, wasn't suggesting he's committed treason. The government confirmed after having reviewed the applicable statute that it had no basis to suspect Mr. Flynn of treason. This entire section has made me realize that I should have included something that was written at page 3, which reads as follows.
Mr. Flynn's case has garnered considerable attention.
Michael Flynn is a retired United States Army Lieutenant General. For a judge to publicly accuse him of treason in a case that he knows has garnered considerable attention, it is what it is.
And it's not good.
But I have no concrete reason for believing that above and beyond common sense and the way things actually played out. Mr. Flynn hired new counsel in June 2019. Before entering an appearance, counsel wrote to the Attorney General and Deputy Attorney General to request a, quote, review of the entire Flynn case for Brady material that has not been produced and prosecutorial misconduct writ large. On July 9, 2019, the Rafikian court unsealed filings indicating that Mr. Flynn would not be testifying. The parties here nonetheless agreed that Mr. Flynn's sentencing should be deferred until at least after the Rafikian trial. For From what I understand, Michael Flynn testifying in the Rafikian trial was the cooperation with the government that might have allowed Judge Sullivan to reduce any sentence he would impose on Michael Flynn's guilty plea. Mr. Flynn then requested 50 categories of documents and information from the government and asked for dismissal of the prosecution based on purported Brady violations. The government characterized these motions as an extraordinary reversal in Mr. Flynn's position, noting that he was now claiming his innocence, quote, despite having admitted his guilt under oath before 2 federal judges. Further, Mr. Flynn had already declined to withdraw his plea in light of the FBI misconduct investigation. It's almost as if the court is saying that Michael Flynn can never withdraw his guilty plea for whatever the reason without automatically becoming guilty of perjury.
But it wasn't a trick. Nobody was trying to trick him.
After substantial briefing, Judge Sullivan denied the motions. In a 92-page memorandum opinion, Judge Sullivan explained that most of the requested information was not, quote, relevant and material to Mr. Flynn's offense or sentencing, that other information was already provided to Mr. Flynn, did not exist, or was not within the government's possession, and that, quote, even if Mr. Flynn established a Brady violation, dismissal would be, quote, unwarranted because, quote, the remedy for a Brady violation is retrial, not dismissal. Judge Sullivan also found again as a legal and factual matter that Mr. Flynn's false statements to the government were material. Mr. Flynn filed his supplemental motion on January 29, 2020. In support, he submitted a declaration signed, quote, under penalty of perjury. This declaration contains numerous statements that contradict Mr. Flynn's earlier sworn statements and representations to the court, also made under penalty of perjury. That he pleaded guilty because of, quote, sudden and intense time pressure, and, quote, intense pressure from the special counsel's office, which included a threat to indict my son, notwithstanding his prior testimony that he pleaded guilty because he was guilty, quote, and for no other reason. That he had told his prior counsel, quote, numerous times that I did not lie to the FBI, notwithstanding his earlier testimony that he was satisfied with their services in advising him to plead guilty, and his refusal of Judge Sullivan's offer to confer with independent counsel. That he had wanted to withdraw his guilty plea prior to his second plea colloquy despite rejecting Judge Sullivan's offer to do just that. That, quote, in truth, I never lied, and that, quote, the truth is I am innocent of these charges despite having repeatedly admitted the false statement's offense. Then Judge Sullivan raises some issues with the Department of Justice's motion to dismiss the charges. Several aspects of the government's filing are notable. First, the motion acknowledges that a Rule 48A dismissal requires leave of the court. Second, the only attorney who signed the motion was Timothy Shea, the then acting U.S. attorney who has since left that post. The motion did not explain the absence of any line prosecutors, including those who had previously prosecuted the case, nor did it contain any declarations or affidavits from witnesses with personal knowledge supporting the government's new factual representations. Third, the motion does not mention Mr. Flynn's March 2017 false statements to the DOJ relating to his work for Turkey, which were described in the statement of offense and were relevant conduct for his guilty plea. Fourth, the government has not moved to withdraw any of its prior pleadings in the case, including its sentencing memoranda or any of the representations it previously made in open court regarding the purported materiality of Mr. Flynn's false statements. Given the absence of adversarial briefing on the issues presented by the government's motion, Judge Sullivan exercised his, quote, inherent authority to appoint former prosecutor and retired federal district judge John Gleeson as amicus. Judge Sullivan appointed him, quote, to present arguments in opposition to the government's motion to dismiss and, quote, address whether the court should issue an order to show cause why Mr. Flynn should not be held in criminal contempt for perjury pursuant to 18 U.S.C. Sullivan then addresses the criteria that are required in order to obtain the issuance of a mandamus. Mandamus is appropriate only where 1. The petitioner has, quote, no other adequate means to attain the relief he desires. 2. The petitioner shows his right to the writ is, quote, clear and indisputable. And 3. The court, quote, in the exercise of its discretion is satisfied that the writ is, quote, appropriate under the circumstances. Mr. Flynn cannot satisfy any of these conditions. Sullivan then goes on to repeat the claim that I feel to be somewhat contentious that the mandamus is even more inappropriate where the court has issued no rulings at all. I think this affirmation is contentious because I'm not of the opinion that the court has issued no rulings at all. On the contrary, like we just saw, the court issued 2 very important rulings. 1, that the amicus present arguments in opposition to the government's motion to dismiss, and 2, to address whether or not Michael Flynn should be held in contempt of court for perjury. Those are 2 relatively important rulings that the court came to as relates to the motion to dismiss. The fact that Judge Sullivan has decided nothing yet distinguishes this court's decision to grant mandamus in Fokker. There, the district judge had rejected the government's effort to exclude time from the Speedy Trial Act clock in a deferred prosecution agreement because, quote, the prosecution had been too lenient in agreeing to and structuring the DPA. Because no decision has been made here, Mr. Flynn does not face any comparable harm. I think Flynn and anyone interested in an orderly administration of justice might disagree with that statement. Unilaterally appointing an amicus, basically self-appointing a prosecutor, adding months and months of delays to an already lengthy trial, I think that qualifies as harm to somebody. This court, quote, cannot use mandamus to remedy anything less than a clear abuse of discretion or usurpation of judicial power. The district court's consideration of the Rule 48 motion does not approach this standard. That is Judge Sullivan's opinion, but unfortunately in this case, the only opinions that matter are going to be the opinions of the 3 judges of the Court of Appeal that are going to hear this motion. Sullivan then goes on to argue that even in the context of a motion under a Rule 48 1998 that granting such a motion is not just a question of being a rubber stamp. The rule, the court explained, does not require, quote, the trial court to serve merely as a rubber stamp. It must be satisfied that dismissal, quote, adequately protects the public interest. To override the government's recommendation, a trial judge, quote, must provide a reasoned exercise of discretion that advances, quote, one or more of the following components. A, fairness to the defense, such as protecting against harassment. B, fairness to the prosecution interest, as in avoiding a disposition that does not serve due and legitimate prosecutorial interests. C, protecting the sentencing authority reserved to the judge. Sullivan then goes on to describe what he feels to be the unusual circumstances of the filing. The circumstances of that filing are also unusual. It was signed by the acting U.S. attorney alone, with no line prosecutors joining it. It featured no affidavits or declarations supporting its many new factual allegations. It was not accompanied by a motion to vacate the government's prior, contrary filings and representations. It cited minimal legal authority in support of its view on materiality. And it did not mention the March 2017 statements regarding Mr. Flynn's work for Turkey that were relevant conduct for his guilty plea and included in his statement of offense, but were unrelated to his January 2017 FBI interview. Now again, call me a cynic if you will, but not only did Judge Sullivan effectively appoint his own prosecutor to take over from the Department of Justice, he has now basically given that self-appointed prosecutor an argument brief. Whether these circumstances could constitute, quote, clear evidence overcoming the, quote, presumption of regularity is a question that has not been fully briefed or decided in the district court. A finding that the, quote, government's later efforts to terminate the prosecution were tainted with impropriety cannot and should not be lightly made. For now, it suffices to say that the unusual developments in this case provide at least a plausible, quote, reason to question the, quote, bona fides of the government's motion. As this court's precedents envision, Judge Sullivan can and arguably must consider those issues before granting a motion to dismiss.
Did you just refer to yourself in the fourth person?
I may be wrong, but these are questions that the judge is within his powers to ask in the context of the Department of Justice's motion to dismiss without having to appoint an amicus to the court, without suggesting that the amicus present arguments for why or if Michael Flynn should be held in contempt of court for perjury, without adding months and months of potential delays to a matter that has already been going on for several years. These are questions Judge Sullivan can ask himself without appointing his own prosecutor to the case. To be clear, a contempt finding or sanction against Mr. Flynn may prove unwarranted, says the judge who appoints an amicus, suggests that the amicus should address that question, and then basically gives the argument to that amicus on that question. But it wasn't a trick. Nobody was trying to trick Michael Flynn. So that is an overview of Judge Sullivan's argument brief in response to the Court of Appeals requirement that he explain himself within 10 days of the petition for mandamus that was filed by Flynn's attorneys. I am admittedly well beyond my expertise in law. I am a Quebec attorney, not a US attorney. I am just trying to make sense of this for myself and to the extent possible to other people as well. My prediction, and I'm crossing my fingers I'm right because I'm going to look so smart in hindsight, is that the Court of Appeal is going to say, this is all fine and well, Judge Sullivan. You can do this on your own in the absence of an amicus. You have meticulously laid out all the questions that can be asked on the Department of Justice's motion to dismiss, and you have the authority to ask them, so go ahead and ask them. You didn't need to unilaterally appoint an amicus. You didn't need to create a schedule that would add additional months to a matter that has already been going on for years. You already have the requisite authority to ask all of the questions you outlined in your argument brief. Go ahead and ask them. Render a decision on the Department of Justice's motion to dismiss, and if people don't like that decision, they will appeal it. But what you've decided to do, above and beyond defying a Supreme Court precedent, has just created a big, ugly mess. That is my prediction. I leave it to the aggregate knowledge of the internet to determine if I am out in left field or if this is a reasonable prediction. I'm also going to be doing a live stream with Robert Barnes where we're going to talk about this very subject in 2 days from shooting this vlog. So if it is Wednesday or Thursday, the link to that live stream is right here. And if it is after the live stream, give it a watch. The link to that live stream is right here. That is the vlog. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below, but be sure to share my channel with someone who you think might appreciate it. That will help my channel grow. If you want to support the channel, all of these support links are in the pinned comment. We've got Patreon, Subscribe Star, PayPal, merch. If anybody wants the merch you get won't have sweat on it, I hope. And now you know your vlog. Peace out. Booyah!